can try me an unwritten law. Show me, you cannot show me, and you're a judge. You claim you're a judge. You don't know law. You don't know law. Nonsense. Where is the family written address? Where is it? Which law gave you the right to waive my family written address? Which law gave you that right? Nonsense. And you want to take and try this? And you want to take the place and try with me? You want to try to do this stuff? You tell you what is not doing here? What are you 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 doing here, Master? What are you doing here? This is the idiot that attacked me. This is the fool that attacked me. That's the idiot that attacked me. That's the fool. Don't touch me. Don't push me. I'm going. Don't touch. Don't touch. I'm warning you. Don't touch me. I'm warning you. Don't touch me. Don't touch me.
They will forever live in infamy. Today is the only day I have witnessed a man being convicted for mere buffering, for what he said from his mouth, not what he did with his own hands. The verdict is not consistent with the evidence laid before the court. The sentence is overbroad, cruel, and unusual. How can you convict a man for making mere broadcasts from a location that was never named, and he never started that broadcast to any single incident of violence, or even someone slapping someone, not to talk of terrorism?
The defendant, having called evidence through cross-examination of all the complainant's witnesses, has given evidence and entitled to the summation of those points through a final written address. So I have actually entered my defense, my Lord. What I did not do is to call a witness, because the evidence tendered by the prosecution were surgically demolished.
By the conviction of Nnamdi Kanu for acts of terrorism, it is clear that justice has been served to the thousands of innocent Nigerians who lost their lives as a result of the inciting broadcast and violent activities of Eastern Security Network. Their blood of those who have died cries to heaven, and God in his mercies has given them justice.
My point is a very simple one, my Lord, very, very simple. My charge sheet, as presently constituted, does not reveal or disclose any written law in Nigeria as at this very morning.
Thank you.
It doesn't exist, my Lord. And
my Lord, consequent upon the conviction, as nothing further remains but the lawful imposition of sentence, the punishment prescribed for the offenses in counts 1, 2, 4, 5, and 6 is death penalty.
You don't know law. Show me where he says you can hold my right to address. Show me the law. Show me the law. I want to show me the law. You don't know law. They are nothing new. You are writing rubbish. God will punish you now and forever. Criminals. Any judgment, let it be on record. Any judgment given in this court is rubbish. Ask him where is the law. Ask for what to show. Where is the law? Where is the law?
The judgment has been delivered. The headlines have been written. And across Nigeria, one question echoes louder than all others. Is there still a way out for Nnamdi Kanu? For years, the legal battle surrounding the leader of the Indigenous People of Biafra has shaped conversation on justice, national unity, constitutional powers, and the limit of state security. His recent imprisonment judgment marks one of the most decisive rulings in Nigeria's modern political history. But even with the weight of the verdicts, the story is far from over. Legal pathways remain, political decisions remain, regional negotiations remain, and history shows that in Nigeria, no conviction is ever truly final until every legal and political options have been exhausted. In this documentary, we examine the 5 major routes through which Nnamdi Kanu can still secure his freedom, despite one of the toughest judgments in Nigerian courts can deliver. This is how Nnamdi Kanu will still be released or get his freedom. When a high court delivers a life imprisonment sentence, the next step in any major criminal case is almost automatic: an appeal. And for Nnamdi Kanu, the appeal process is not just a routine legal step. It is the strongest and most realistic pathway to freedom. 1. The Court of Appeal. First stop, critical stop. The judgment was delivered by a federal high court. The next destination is the Court of Appeal, which has the power to set aside a conviction, reduce the sentence, invalidate the trial, or order a retrial. Appeal courts do not focus on emotions. They focus strictly on errors, procedures, and constitutional compliance. And in Kanu's case, his lawyers have already identified several angles they believe could overturn the ruling. A. Fair hearing consent. The argument is simple. If Kanu was unable to present a full defense, or if evidence were admitted improperly, the appeal courts could declare the trial flawed. B. Errors in interpreting the terrorism law. Kanu's team have constantly argued that the law used against him has undergone amendment and repeals. If the appeal court agrees that the wrong version of the law was applied, the entire conviction could collapse. C. Issues surrounding admissible evidence. Appeal courts often overturn judgment because of improperly admitted confessions, unauthenticated broadcasts, or insufficient linkage between the defendant and the alleged acts. D. Precedents. This has happened before. And appeal courts in Nigeria have overturned terrorism-related convictions in the past. Legal history shows high-profile convictions frequently fail under appeal because the standards for proof at this level are much stricter. So while the judgment looks heavy, it is not indestructible, and the Court of Appeal is where its strength will be truly tested. If the Court of Appeal affirms the conviction, the journey does not end. Kanu's case can and almost certainly will proceed to the Supreme Court, the ultimate authority in Nigeria's justice system. 1. Why the Supreme Court matters more than any other thing. The Supreme Court has the power to overturn the appeal court's decision, dismiss the charges entirely, reduce the sentence drastically, or order a total retrial. This is not theoretical. It has happened numerous times in Nigeria's legal history. High-profile political, criminal, and corruption cases have been reversed, corrected, or completely reshaped by the Supreme Court. And 2. The Supreme Court focuses on constitutional questions. Unlike trial courts, the Supreme Court places special emphasis on whether a citizen's rights was violated, whether the government followed due process, and whether constitutional standards were met. In Kanu's case, the Supreme Court could review A. The legality of his 2021 rendition from Kenya. The Supreme Court may rule that government acted unlawfully. If so, the court may determine that the trial itself was tainted from the beginning. B. Whether the trial judge interpreted terrorism law correctly. If the Supreme Court disagrees with the judge's interpretation, even partly, the conviction may not stand. C. Whether the evidence met the required burden of proof. Supreme Court scrutiny is far more demanding than that of a lower court. In several past cases, the Supreme Court has freed people who were convicted of serious offenses because the evidence did not meet the highest threshold required. And now to number 3, historical precedent. The Supreme Court changes everything. Some of the most shocking legal reversals in Nigerian history have come from the Supreme Court. Therefore, for many legal analysts, Kanu's freedom is most likely to emerge from this court, not the one that convicted him. The appeal process is long, but it is the strongest and most legitimate path to his release. Nigerian's political history shows one undeniable truth. Some cases are resolved by law, others are resolved by politics, and a few are resolved by both. Even after a conviction, the Nigerian Constitution grants the President extraordinary powers under Section 175 to grant a pardon, to give amnesty, or to commute a sentence. These powers exist for one reason: to give the government flexibility in resolving politically sensitive cases, especially when national stability is involved. 1. The presidential pardon, a powerful option. A presidential pardon can instantly end Kanu's imprisonment. It overrides the judgment entirely. Past presidents have used this to free condemned criminals, political prisoners, and high-profile convicts. It is not new, it is not controversial, and it is constitutional. 2. A negotiated settlement. The federal government can reach an agreement with Southeast governors, National Assembly representatives, Ohanaeze Ndigbo leadership, and civil society groups. Such negotiations can lead to conditional release, monitored freedom, or future political commitments. If the government believes that Kanu's release could calm tension in the Southeast, improve national unity, or restore stability, a political settlement becomes very possible. And the third option, amnesty modeled after Niger Delta peace talks. Nigeria has a history of solving crisis through political negotiation, not force. The Niger Delta militancy crisis did not end because courts won. It ended because the government negotiated. If dialogue is opened, the federal government may consider partial amnesty, supervised release, or transitional peace agreement. And the fourth option, why politics could override the court's judgment. Sometimes government chose political peace over prolonged confrontation. If future leadership, whether this administration or the next, believes national unity demands reconciliation, the political option becomes one of the most powerful paths to Kanu's freedom. Even when court judgments are final, external pressure can influence how government manage politically sensitive cases. For Kanu, two forms of pressure matter. One is the domestic political pressure. 2. The international human rights pressure. Let's look at the number 1. The domestic pressure. Southeast leaders and political representatives, governors, senators, and traditional institutions from the Southeast can lobby the presidency, push for reforms, request constitutional release, and negotiate through political channels. Domestic pressure has worked before in multiple Nigerian cases. It can work again. And to the second one, international human rights organizations. Groups like Amnesty International, Human Rights Watch, the UN Working Group on Arbitral Detention, and the African Commission on Human and People's Rights can influence political decisions by issuing reports, calling for review, or urging negotiation. While these cannot overturn the judgment, they can shape how government responds to it. And 3. ECOWAS Courts, a powerful regional mechanism. The ECOWAS Court of Justice can cancel a Nigerian court judgment, but it can declare that Nnamdi Kanu's rights were violated, award compensation, or insist on reforms. Though its ruling are not always strictly enforced, they create politically and diplomatic pressures that government sometimes responds to, especially in cases that affect regional stability. 4. The diasporal influence. The IPOB diaspora network is active across Europe and North America. Pressure from diaspora communities can shape diplomatic conversations, especially in countries with strong Nigerian communities like the UK, the US, and Canada. While these pressures does not change the legal judgment, it can accelerate a political settlement. Beyond the legal and political strategies, there are additional parts, less dramatic but still powerful. Release on medical ground. If Nnamdi Kanu's health condition deteriorates significantly, his team can file for bail on medical grounds, conditional release, or a transfer to a less restrictive facility. Nigeria has granted medical releases in previous high-profile cases. 2. Sentence commutation. Even without a full pardon, the president can convert a life sentence into a fixed-term sentence, time served, or supervised release. 3. The judicial sentence review. Future legal reforms or judicial interpretations can lead to reopening of sentencing, sentence reduction, or reclassification of convictions. 4. Time already spent in detention. Legal teams that can argue that the year he has already spent in custody could count towards his sentence, especially if the government opts for a commuted sentence or political agreement. These humanitarian and administrative options are less dramatic than appeals or pardons, but they remain legitimate and often used mechanisms for securing the release of high-profile inmates. The judgments may have been delivered, but the story has not ended. Nigeria's legal system provides multiple avenues for review. Nigeria's political system provides multiple avenues for negotiation. And Nigeria's constitution provides multiple avenues for mercy. Appeal courts may overturn the conviction. The Supreme Court may reshape the legal foundation of the case. And the presidency may initiate a political settlement. Regional leaders may negotiate peace. International pressure may put for reconsideration. Humanitarian ground may open in new parts. And in every direction, there remains a possible road to freedom. The road ahead will be long. It will be political, it will be legal, and it will be historic. But one truth remains clear. Even after a life sentence, Nnamdi Kanu still has multiple realistic pathways to regaining his freedom. This is the next chapter in one of the most consequential political trials in Nigeria's modern era.